Hi there everyone, welcome back. We are going to continue on from our last video and we are going to talk about what happens when there is interbranch conflict during times of war. We're going to focus particularly on recent times, including the war on terror. So be advised this video is going to discuss things like the Iran hostage crisis and the war on terror. All right, so remember, we've been talking about the importance of having a unitary executive during times of war. And the reasons behind this have to do with the need for decisive action and secrecy during times of war. And so this is preserving the ability for the nation to act unilaterally, decisively, and quickly. And so the idea is that at times of war, these things are even more important, and so it's more important to have a powerful executive. Of course, during the last video in Youngstown Sheepman 2, we talked about this idea that the degree to which the president has power, even during times of war, may be dependent upon what Congress thinks about what action the president is taking. So we're going to explore that a little bit more here today. And we're going to start by talking about the Iran hostage crisis. So this case is Dames and Moore versus Reagan, and this isn't Ronald Reagan. This is actually Ronald Reagan's Treasury Secretary. The material facts have to do with the November 1979 seizure of the U.S. Embassy in Iran, and we were in the process of trying to negotiate getting the hostages freed. And as part of this process, President Carter invoked the International Emergency Economic Powers Act. And as part of it, he froze Iranian assets that were in the country in order to use these as a bargaining tool later on. And indeed, upon the release of the hostages in 1981, this is under the new President Ronald Reagan, Ronald Reagan's Treasury Secretary affirms those agreements to take the money that was Iranian money within the United States and to send that back to Iran, withholding some of it for the distribution from a tribunal that would help to settle claims against the Iranian government. But it would also halt all lawsuits or suspend all lawsuits that were currently in progress against the country of Iran from American citizens. So the legal question here is whether the president has the authority to transfer the Iranian funds and nullify legal claims against Iran. So the holding was unanimous. And the court said that yes, the president does have this power. The beginning of this opinion talks about how very, very narrowly they plan to decide this case. And they also talk about the fact that they're going to be relying on Justice Jackson, in part for his concurring opinion in Youngstown Sheepman 2. So the court starts out by talking about the way that Carter used the IEEPA in order to justify these steps that he had taken, and that he needed this in order to be able to use that money as leverage in his negotiations with the Iranians. The court talks about the fact that it seems like this is the sort of thing that Congress had in mind when they passed this law. And so because it seems like Congress is okay with it, the president is actually at his maximum power in this situation. And as for the question of suspending cases in the federal judiciary, this is where things could get dodgy, right? Because this is a situation where the courts are asked to essentially step back and cede some of their role in this process. But the court here says that Congress is probably okay with this too, that it seemed again to be in the same spirit of the laws that had been passed that Carter had been relying upon. And indeed, they point to the fact that this arrangement also gave access for Americans to this claims tribunal where they could go and have their claims litigated and perhaps actually get back some of the money that they felt that they were owed from Iran. And so in a way, they kind of said, quit complaining, you got it better than you deserved. So after this, we had a situation where Congress balks, right? And so what happens if we have a situation where the president finds himself not in this maximum category where he's got essentially the permission of Congress, and not in that intermediate category where Congress really hasn't said anything either way, but in a situation where Congress actually actively comes out against what the president is doing. And so we have to concentrate on the logic for presidential power and what happens when Congress actively tries to undermine the president's policies here. And so the court's going to ask again, what would Justice Jackson do? And by this I mean they're going to apply Youngstown Sheehan 2. So we see this in Zivotofsky versus Kerry. This is a 2015 case. And the facts are this. The Foreign Affairs Manual is a creation of the executive branch of government, and it essentially details the way that the executive branch policy dictates the recognition of various sovereign countries. And in this Foreign Affairs Manual, Jerusalem was noted as essentially disputed territory and was not listed as among the cities in Israel. In 2003, Congress actually completely overturned this by statute. And this litigant, Zivotofsky, wanted the passport for his child, who was born in Jerusalem, to read Israel as place of birth. The legal question here is whether this law impermissibly infringed on the president's power to recognize foreign states. So essentially what Congress was doing was saying, we see that the president has decided not to say that Jerusalem is part of Israel, but we disagree, and we are going to try to force him to change his ways. So the holding here was that, yes, this infringes inappropriately on the power of the president to recognize foreign states. And so in Kennedy's opinion, he points out that it is true that presidential power is at its lowest when it goes directly against Congress. And so in Justice Jackson's words, in this situation, the president can rely only upon his own constitutional powers minus any constitutional powers of Congress over the matter. Here, though, Kennedy points out that the president has the exclusive power to grant formal recognition to a foreign sovereign. And also, to say anything else is really impractical. So you can see, again, this is a functionalist argument about why it makes sense to have a unitary executive that has the power to decide whether we're going to recognize certain territories as being part of certain countries. Breyer's concurrence essentially argues this is a political question and we shouldn't be answering it, but yeah, okay, if we're going to answer this question, then I'm okay with this answer. The dissents, though, push back very strongly against this idea. So Thomas concurs in part and dissents in part. And he argues, look, I get the whole passport thing, right? The passport is this document that has very much to do with what the president is doing in terms of recognizing foreign countries. That's fine. But Congress is the one that has the power to deal with questions of naturalization. And the consulates can be forced to list Israel because that's naturalization stuff. And that is Congress's duty, and it's their power, their sphere of influence. Scalia dissents here and is joined by Roberts and Alito. His argument is that the whole thing is a naturalization question, and so all of this is within Congress's power, and that the president can't really assert any power or authority over this question. That it doesn't really have anything to do with whether or not the president and the executive branch recognizes a certain territory as part of a certain country. Besides, he argues that we should respect the way that citizens choose to self-identify. And since this person identified as being from Israel and not Jerusalem, that is important for his country to recognize that. So this is a really interesting argument to come from Scalia. Roberts also writes a separate dissenting opinion, and Alito joins it. And his argument is basically that the president is defying a law of Congress, and the court is okay with that. And he's not. He thinks this is completely bonkers. All right. So then we get to 9/11 and the war on terror. And now we start to see this shift again. We see the president and Congress now largely presenting a united front in terms of how they want to deal with enemy combatants that are apprehended in the theater of war and detained. So one of the things that they seem to agree about is about taking power to decide these sorts of complaints away from the courts and placing them instead in executive branch military tribunals. So this harkens back a little bit more to the military tribunal cases from the Civil War and World War II that we talked about in the last video. So now we have to watch the way that the court tries to navigate these issues. And it is pretty interesting, I think. So we start with this question of citizens who are also enemy combatants. So this is the case of Hamdi versus Rumsfeld in 2004. The material facts here are that Hamdi was an American citizen who was raised in Saudi Arabia, and he was captured in the war zone and was delivered to the United States by Afghan forces. He was assigned enemy combatant status, and he was held without charges. And so he filed a habeas corpus petition to challenge his confinement. The legal question in this case was whether the executive branch can detain citizens who are also classified as enemy combatants. And can that person then challenge their enemy combatant status in the federal court system? So the holding in this case was a split decision, and it was split in two different ways. In answer to the first question, it was a 5-4 decision, yes. And the second was a 8-1 decision, no. So the first part of this is covered by the plurality reasoning in O'Connor's opinion. And her argument is that there is no bar, necessarily, to holding a citizen as an enemy combatant. And we learned that from ex parte Kieran. Preventing combatants from returning to war is a fundamental duty during wartime. And so this is a huge concern. And Congress, the court argues, authorized this kind of military tribunal. However, the court argued that this cannot be for the purpose of interrogation. This can only be for the purpose of keeping this person from going back to war. The court held that this combatant can challenge that enemy combatant status, however, not in a civilian court and not necessarily to the standards that are afforded people in a civilian court. So essentially, we leave this case with the notion that as long as a military tribunal could provide adequate opportunity to challenge enemy combatant status, then these enemy combatants, although they have the right to challenge that status, they would not necessarily have the right to challenge that status in the federal court system. The dissents in this case are interesting. The first is from Justice Souter, who concurs in the judgment and otherwise dissents, and is joined by Ginsburg. And his argument goes like this. The authorization for the use of military force, he argues it does not actually authorize this kind of military tribunal, and that the plurality opinion is just wrong on this. He also points out that this is starting to look a little bit like Korematsu, that here we have citizens being detained indefinitely without charges, and that that's a big problem. Also raises the point that it isn't clear, or at least it isn't self-evidently clear, that these folks aren't actually prisoners of war who would be subject to the Geneva Convention protections. So Souter and Ginsburg argued that he shouldn't be detained at all. Now Scalia dissents and is joined by Stevens, which is a fairly unusual combination. And Scalia talks about how this is a very, very, very big deal to be detaining a citizen without charges indefinitely. He argues that the government has two choices. One of them is that they must charge him and try him in court, and the other option is to just suspend the writ of habeas corpus. So he argues that the AUMF did not actually suspend the writ of habeas corpus, and you can't kind of suspend the writ of habeas corpus. It's either there or it's not. Thomas dissents here, and interestingly, Thomas is on the completely opposite side of this. He argues that war powers of the president cannot be balanced away. This is exactly why we have a unitary executive, in Thomas's opinion. He argues that if the president wanted to, the president could do this on his own authority without the help of anybody else. But in this case, Congress actually did authorize this, according to Thomas, in the AUMF, and so that's just a bonus. That just increases even further the president's authority in this situation. And he also argues that Scalia is just wrong here, and he's way too inflexible, and he's really compromising the ability of the federal government to protect citizens from terrorists. So then we commence this continuation of the fight about habeas corpus. And it is true that the court usually tends to hang back a bit in wartime decisions. But here, the Congress and the president seem to be conspiring to ice out the courts. And so in this situation, this is a bit of a delicate dance for the court. The court is facing two branches of government who are trying to do an end run around the federal court system. So the next case is Rasool versus Bush. This is also a 2004 case. The facts in this case are there's a group of Australian and Kuwaiti detainees, and their families filed habeas petitions on their behalf. The legal question here is whether the federal courts have jurisdiction to consider habeas corpus petitions and other kinds of similar petitions from foreign detainees in Guantanamo Bay. The holding here is 6-3, and Stevens wrote for the court. And Stevens argues that yes, federal courts do clearly have jurisdiction here. And his argument was essentially a refutation of the government's argument that because Guantanamo Bay is actually in Cuba, and that the U.S. federal government made a point not to take sovereignty over that territory, that the federal court system does not have jurisdiction over Cuba. And so Stevens' argument is basically, look, it's Cuba, but it's not really Cuba. I mean, the United States government controls absolutely everything that happens in that base at Guantanamo Bay. And so to say that somehow the court system wouldn't have jurisdiction there just doesn't hold water. And he also argues that you absolutely do not need to be a citizen in order to make use of the habeas corpus petition. Scalia, joined by Roberts and Thomas, dissent in this case. And they're arguing that this is a complete 180 from everything the court has ever said about habeas corpus. And they argue that the majority is essentially springing a trap on the president, surprising him by saying, oh, out of the blue, we're going to decide that all of these people get access to the federal court system, even though we don't think they've ever had it before. So again, there's this argument that these non-citizen enemy combatant detainees don't get the benefit of accessing the federal court system or a writ of habeas corpus. The next case is Hamdan versus Rumsfeld. This is a 2006 case. And the facts here, the case has to do with Osama bin Laden's chauffeur, and he is detained at Guantanamo Bay. He files a petition for a writ of habeas corpus. And during the time his petition is under consideration, he is held in front of a military tribunal, and that military tribunal finds that he is indeed a combatant, even though his job was just to drive a car around, and he wasn't sort of fighting in any traditional sense of the word. Meanwhile, during the course of this process, Congress passed the Detainee Treatment Act of 2005. So the legal question that's brought up here is, does the Detainee Treatment Act of 2005 keep the Supreme Court from hearing the petition? Because this law essentially removed from consideration of the court all future habeas corpus petitions. And then the second question was whether the president has the power, with the help of the AUMF and the Detainee Treatment Act, to constitute this kind of military commission as a substitute for a trial in the federal courts. So the holding of the court is 5-3 split, no and no. Stevens writes for the majority, and Roberts didn't take part in this because he had been on the DC Circuit Court that dealt with this case. The first question is about whether the DTA keeps the Supreme Court from actually hearing this case. And here, Stevens is kind of, he's kind of being a little bit dodgy. What he says is, look, the Detainee Treatment Act didn't say that currently pending cases that we've already agreed to hear can't be heard. So we're just going to assume that Congress didn't mean to take jurisdiction away from us on these cases. He goes on to talk about how the DTA and the AUMF don't expressly authorize this kind of commission, and the inherent powers of the president are not enough here to actually allow for this without the help of some sort of act of Congress that permits this. He also argues that the Geneva Convention applies and that the Supreme Court will be here to apply it. Now, Breyer files a concurring opinion, and Kennedy, Souter, and Ginsburg join him. And what he argues is that these tribunals might have been okay had Congress actually approved of them. So here you can see that the court and the various kind of groupings of judges, these different voting blocks, are applying Justice Jackson's kind of 3-point analysis of how strong the president's power is relative to what Congress thinks. And this is a fun little throwback to Youngstown Shooting 2. Now, Scalia dissents, and Thomas and Alito join. And they argue that, number one, the court doesn't have jurisdiction. And to be fair, Scalia kind of has a point here. Scalia says, look, obviously Congress did not want us to hear this case. They were clearly trying to remove our jurisdiction from cases like these. So this argument that, well, they didn't actually mention pending cases, so they must have meant we should hear this, is just a little bit silly. He goes on to argue that we should at least wait and see if the military tribunals that they set up actually do provide a reasonable and appropriate amount of protection before we start declaring them unconstitutional. Thomas actually delivered his dissent from the bench, which is incredibly, incredibly rare for Justice Thomas. Usually he has the reputation of never uttering a word in the courtroom. So this is a very unusual situation. He argues that the court has absolutely no jurisdiction here because Congress clearly stripped the jurisdiction. He also argues that Hamdan is not at all covered by the Geneva Convention because he's not a prisoner of war. And even if he had been, it would still be absolutely fine to try him in a military tribunal like this. Also, he points out, for the record, this war on terror started in 1996 with the first bombings, not in 2000 at 9/11. And he also really wants to know why everybody seems to be acting like this guy isn't guilty. So he is clearly concerned with the idea that the court could be getting in the way of protecting people against terrorist suspects. The last case we're going to talk about today is Boumediene versus Bush, and this is a 2008 case. The material facts here are that right after the Hamdan decision, Congress actually passes the Military Commissions Act in an attempt to say, yes, we co-sign these commissions and these military tribunals. So now you can't say that the president doesn't have our approval because here we go. We're giving it to him right now. So this law also killed federal court jurisdiction for habeas corpus petitions coming out of these military tribunals and out of the detentions in Guantanamo Bay. So the legal question is whether the MCA is unconstitutional as far as it strips access to the federal courts for these detainees. The holding is a 5-4 split, and Stevens again writes for the court in the affirmative. He argues that the military tribunals that are created in the MCA do not provide an adequate substitute for the habeas corpus petition. And this is because it relies on the Detainee Treatment Act that was passed earlier. And essentially his argument is, nice try, Congress. We see that you were trying to find a way to get us to change our mind and to step back from all of these cases and let the military tribunals handle this. But Stevens isn't having it. Of course, the dissenters are just absolutely flabbergasted by the idea that enemy combatants are now getting habeas corpus rights. And of course, I would imagine that Scalia is probably particularly concerned because these enemy combatants are not also American citizens. So that's going to be it for today. Have a good one, and I'll see you back here next week.